All right. Good afternoon, everyone, and welcome to another edition of Fire Law Roundup for May 23rd of 2022. And Brad is coming to us live from New York City. But Brad, why don't you take it away?
Fantastic. Well, hopefully I won't get too distracted by all the FDNY fire and EMS passing us. I'm going to go in no specific order from your blog, maybe some shorter ones first. But let's talk about, and it's, you even linked to this. I almost thought I went back in time. We'll go to Connecticut, where the firefighter's drug death leads to discipline of 8 others. And I'm glad if our viewers will watch or read the blog. We actually dealt with a very similar one a few weeks ago. This is just short, but it has an interesting twist that I would like to raise. So here, there's an off-duty death of a New Britain firefighter. And as a result of his death, I'll explain why, several officers were terminated and or suspended, demoted, and because they said that and this was pretty recent, January 26th of 22.
It was all this year. It was all this year.
Yeah, I mean, this is very current. But this firefighter apparently had a known history of drug use, but there was an investigation that led to this dismissal, the lieutenant, et cetera, which was just in February, for knowingly supplying, giving, selling, sharing, and using illegal drugs and prescription Adderall pills, and then lying about it. Now, my first question was, were they getting this from the station? But obviously, Adderall isn't something that any fire department or ambulance is going to carry. So this is completely, unless you have a different twist, off-duty conduct.
I think some of the transactions may have been taking place on duty. I think that was some of the, and I have no idea. I don't have any backstory to this, but I think there may have been some connection to work, but the drugs weren't being stolen from work.
No, and that one, I won't get too much into the other one to juxtapose with it. Similar, but very importantly, different facts. But here it's completely, as far as I can tell, completely off duty. And yet they're actively, they think they're helping him. But, allegedly, I guess, but they're, he then ends up dying as a result of this. And as a result of the off-duty conduct of these firefighters, they're disciplined. So I am curious, one, what the CBA says. I mean, there's a lot of information we don't have. I don't know if there will be challenges to this. But, off-duty conduct clearly is a big topic for unions to discuss. And I understand why it's important, right? You're always out there in the community, and what you do off-duty, whether it's stealing or drug use or sexual misconduct or taking a picture in Hooters in your Class A uniform, right? I mean, all real things, but they affect you. But here, it seems completely off duty. So I think that's the critical part is, if I'm a union or anybody, even a volunteer, I'm looking saying, what is my culpability for any off-duty conduct? And I'm not justifying or not justifying what was happened. My focus legally is on, my God, this was off-duty.
Yeah, and there's a complicated Garrity issue that arises because an employer can order a firefighter, a fire chief can order a firefighter to answer questions about what took place at work or that, has a direct connection to work. But the chief can't order that kind of answer. And I'm kind of stumbling over the words here, but we use the term compel. You can compel the employee to answer questions about things that are specifically, directly, and narrowly relating to the performance of their official duties. That's the official.
But not if you can be convicted of a crime.
Well, you can, and here's the thing: under Garrity, once you do that, it's immunized. Okay, and so if let's say we were in the same department, I'm the chief, you're one of my officers, and there was a drug transaction that took place at the station, I can order you to answer the questions, and your answer back to me becomes immunized. It can't be used against you in a criminal case. Now, the problem can be if let's say you gave you did some drug dealing in the station but most of your drug dealing was off duty. I can't
As it would
immunize,
be.
right, as it would be. I can't immunize that off duty,
Right.
your answers to questions about off duty activities. So therefore, if you answer those questions, and that's why you want to have a lawyer with you, but if you
Right.
answer those questions about off duty, it's not immunized,
Right.
and you can be charged.
But as I
So
understand, Garrity,
yeah,
you give me the warning. I don't
yeah,
have to answer them, basically my Fifth Amendment rights, right?
mhm.
And you can't penalize me for not answering it.
No,
Is that
no,
correct?
that's no, no, and this
You
is why
can
it's so
penalize me.
complicated. It's that's what you just said is what I was taught in law school, and it's wrong, and it's wrong. You would think a
Right.
law professor would know this, okay? Your professor and mine probably were the same mistaken, approach. You, and I know you were a fire chief. You can order your firefighters to answer questions under threat of termination about a work-related matter. I use the term SDN, specifically, directly, and narrowly. They have to answer questions that are specifically, directly, and narrowly relating to the performance of their official duties. Once they do, the answers become immunized. Okay, and you and I have an understanding about what is immunity. It's not really immunity in most states. Okay, it's really this. It's basically it's going to be suppressed. Okay, it's under the exclusionary rule. Okay, MAP v. Ohio. So, but it's going to be exclusionary. But the bottom line is, you as the chief can order your subordinates to answer work-related questions. It's got to be SDN. But when you're engaging in behavior that involves both on duty and off duty, it gets very, very complicated, because if you ask them about off duty activities, you are absolutely right. You can't use their silence against them. So it's certainly from from the fire department's perspective, you need competent legal guidance to guide the investigation. From the union's perspective and the firefighters' perspective, you need competent legal guidance so that you duly represent the firefighter who finds himself in this situation.
Now, I've had an issue, which I love, and I know this is so far off topic, but
Yeah.
Here you have several alleged wrongdoers.
Yeah.
I had an issue many years ago. It was a great issue where all of the wrongdoers conspired, so to speak, agreed not to say anything except for one.
That's all it takes.
That's all it took. And the one, under the promise of immunity, hey, you talk to us, and the fire department says, you tell us about the other, there was 3 or so, and you're okay. It turns out he was the main actor anyway. He throws the others under the bus. They get terminated. He gets immune. They all clammed up, and it didn't work for him. So, it only takes one.
My dad, my first year of law school, my dad's law office was right around the corner from where I was living. And I used to pop in there after school and ask him, like, bounce things off. So I was asking him some questions, like stupid first year law student questions about conspiracies. And he, early in his career, he did a ton of criminal law. He was doing mafia defense kind of stuff,
And he lived to tell about it.
And he did. He kind of got, he ended that after one of his clients got bumped off. So, and
probably just found him in Lake Mead in the
but at any rate, he gave me a really good analogy, and it comes back to me. It comes back to me clearly, vividly, whenever we talk about it. He says, look, conspiracy is like a bunch of people in a canoe. And as long as everybody stays in the canoe and they're all paddling, you're going to go down, the river nice and easy. All it takes is one guy to stand up and everybody's going over.
Right.
Right. So, and whenever I think of a conspiracy, I think back to that conversation. So.
All right, perfect. Let's move on to Oklahoma. This is great. This is if you're okay with moving to Oklahoma.
Yeah. Oh, yeah. Yeah.
So Oklahoma just enacted a law, and I find this so incredibly interesting. I understand why. I'll give you my thought, and I can just juxtapose it to a number of other states. But Oklahoma now enacts a law that allows, very limited, for a transport of an EMS patient on a fire apparatus. But the caveat is you got to have medical control to do it. So medical control's got to approve that. And wow. So, here, I'm not going to get into the background if it's okay, unless you want to, but the background of what caused this to happen. But obviously there was an instigating incident where there was discipline as a result of a transport of a patient, I believe a child in 2020 on an engine. And, this is made for television type stuff, right? You see this in cop cars, they grab the baby.
It's drama. Yeah.
It is drama, but here's the thing. About 3 weeks ago, you and I had a case where the BLS agency arrived, waited 20 minutes for the ALS entity arrive, advised the mother, I think, I'm trying to do this by memory, that, hey, we need to wait for ALS. And obviously bad things happened while waiting, and the judge says you should have transported. And here, when the firefighter is saying, we can't wait the 5, 10, 15, 20 minutes for the ambulance to get here. We're going to scoop and screw is the term we used, right? Grab and go, pick any term you want. And we're going to put the patient in the back of the fire truck. And look, a lot of these trucks are BLS or ALS trucks anyway. They can, or engine, right? They can treat the patient accordingly on the way to the ambulance. So, but here, it took a state law to do it. Now, in a lot of states, there is no law that says only an ambulance may transport a patient. There are limits among which ambulances can transport, but New York State, by the way, is the most heavily regulated EMS state about licensure, because we're one of the few states that still has a certificate of need process that limits who can receive and who can pick up a patient. It's a huge fight. The reason I was late to this is because I was just having that call. But so it not just any ambulance can say I'm going to operate. In New York City, a license to pick up a patient goes for $4 or $5 million for an ambulance company. So in any event, when the fire department start picking up your patients at $300, $400, $500, taking the money away from you and start transporting because they don't want to wait, it's going to create a big problem. And obviously this is a big political issue. It's a great issue. I'm not taking sides on it. I can understand both sides, but my more interesting part of this is the medical control. Medical control approval is needed. So now you've got to pick up the phone. Presumably medical control has to receive certain information, right? And guess who's bearing the liability now for all of this, right? And I don't know in Oklahoma if medical control has any permanent or qualified immunity, absolute or qualified immunity, but medical control is going to have to know how far away is the ambulance? What services do they offer? What are the risks of transporting? What are the risks of not transporting? And if I'm Oklahoma, I am creating a policy, right, for the fire department that goes through a list of questions where you better have the answers and you better relay that. And you better have about 107 attorneys, 2 of which should be you and I, review this pre-transport checklist where you darn well better clear it. But I'm telling you, the lawsuits that are going to come from this about you picked up, you grabbed and went, or you didn't, and you could have and should have, floodgates are going to open. I hope. I
hope not. I hope not.
I hope not too. But from the little part I saw, I didn't see a lot of immunity provisions, unless I missed it.
I'm sure there's immunity. Most states have immunity, but I mean, that's so easy to get around, like most states, because it's usually immunity for negligence. Okay. So, right. So as long as you weren't grossly negligent, you're not going to be liable. So what does the plaintiff do? They allege gross negligence. And now it's a question of negligence, gross negligence, and it still ends up in front of the jury. So, which for
the viewers is your conduct was so likely to cause injury, right? Or you were so careless it was going to cause injury. Anyway, you and I can turn a 1-minute topic into an hour.
But this is a good one, and I really, I feel bad. I feel bad for everyone involved in the original incident involving this case. That you have firefighters who are frustrated by the EMS agency. You have the department that really is sort of caught in the middle. You have state laws requiring certain things. You're trying to do the right thing for your people. You're trying to do the right thing for the public. You're trying to do the right thing for the state. everyone involved in this was in a very bad situation. And I think they did the adult thing. And I think that's where they need to be commended, because the fire department got together in the aftermath of this. Hopefully, I'm assuming they work with the local, the union, and maybe the state union, and they went to the legislature and said, fix this, because we want to have some sort of a process. Now, you point out some concerns that could arise, and yeah, that there are some concerns, but waiting 2 hours for a private ambulance to show up is just crazy. And they have a history, the private ambulance has a history of saying we're right around the corner when they're not. Leads to all sorts of other problems on that level. So at any rate,
the state legislature, I'd mandate GPS in every single ambulance and fire truck.
Yeah,
that's the only way we can solve it. Yeah. Okay. Anyway, but I think that's a watch what happens in the next couple of years.
I got my fingers crossed for him, and I'm really I'm glad to see that it went this way, and I think that is the solution, subject to the concerns you raise.
The funny part, though, is a cop can do it, throw a baby in the back of the police car, and nobody would say boo.
Yeah.
They could put out our fires too, and no one cares.
I've transported on engines before, and it's been a dire situation, anaphylactic, type of thing. But where there's no ambulances available for whatever reason, and there's the person's we gunshot. I remember transporting, we had 2 gunshot victims, and we were 3 blocks, the shooting was 3 blocks from the hospital, and we just threw them on the tailboard and drove slowly to the hospital, because we could get to the hospital faster than a rescue could get to us. But that was back in the 80s, early 80s, and you just can't do stuff like that anymore.
Right. Or maybe you can. Okay.
I guess in Oklahoma maybe you can.
Yeah, this is a horrible story. I don't even want to talk about this, but a San Francisco firefighter was charged with felony assault, my God, for attacking a colleague. And this isn't the story, believe it or not, right? For attacking a colleague, he grabs, who's another firefighter. They've known each other for 20 years, same station, I believe. I don't know what the motivation was, but he grabs a spanner wrench, right? We in the fire.
It's a little bigger. It's a little bigger than a spanner, but it's more like, but it's smaller than a hydrant wrench. So I understand it's called, and I got it in the thing. It's called a large brass spanner, and the video I have there shows a picture of it. But
it looks like it hurts. Put it that way. I don't want to be beaten with it. Anything heavier than a feather. But in any event, they knew each other for over 20 years. The guy, right, the assailant, goes to the firehouse, finds the victim's address, home address, grabs the large brass spanner, goes to his house, and beats him up. All right. And then somebody calls, and I for some reason thought it was a woman who was being beaten. I'm not going to, make any comment, but he says a woman's being beaten. In any event, the police go arrest him. He had left the scene, I think, by the time, but they get him, and he's charged, as he should be, with assault with a deadly weapon. But the interesting portion of this is whether the fire department, because they're claiming you should have known he had violent tendencies. And so now, circle back to our first issue, we talk about off-duty conduct. Now we're bringing it back to a workplace violence issue. And by the way, workplace violence programs are mandated by federal law, as if you're an OSHA follower. But and probably most states, I'm going to guess, have workplace violence. But the question, there's so many good duty questions. What did you know? Could you have known? Should you have known? What was reported? And normally I would say, like, look, on first surface facts, there's no liability here. It's horrible to think that a brother attacks one of our own, but the allegation going to be, right, that the fire department, the chief and whoever, should have known about his violent tendencies and aggression. I didn't see anything that says toward this individual specifically. I don't know, but wow, I don't know what else more to say.
Yeah, it raised a good point, because this is not the first one and first case where we've seen allegations that a fire department was aware of a firefighter's violent propensities, that somebody has been either violent in the past or they've threatened violence in the past. and the department did not protect the other firefighters. And there's a couple of lawsuits now. There was a shooting that took place in, I think, LA County.
LA, yes.
Right. And where there were allegations that the shooter had a history of these violent outbursts and different things. Now, if you kind of put that issue to one side, okay, that's a big concern. It gets into threat assessment, and departments need to be ready for that. On the other side of the football field, you talk about one goalpost at one side. Now we'll talk about the other goalpost. I've seen fire chiefs weaponize their discipline process to fire people who made almost like a joking threat. Okay. And yeah, I'm gonna punch you in the eye. If you come over here, I'm going to punch you in the head, or I should have killed you when I had the chance. Okay. We're seeing firefighters terminated for that. And I think at the center of this is fire departments don't have a good threat assessment policy or procedure. They don't know what to do. And when the chief or the administration doesn't like a firefighter, they say, I know how I'm going to handle this. And on the other hand, when you have an employee who's maybe a high performer, or maybe for whatever reason, the department chooses not to go after that person, now they're at risk of ignoring the problem and perhaps finding themselves in a situation like we see here in San Francisco, or as they saw in Los Angeles, where they allowed somebody to continue and didn't address the violent behavior.
Well, let me tell you, because I'm one of those people. When I was fire chief, and this is a matter of public record, so I can say what I can say, but when I was fire chief, I was told that a police officer from our town's police department, we were a village fire department, walked in armed, made a very threatening comment to another individual looking for a firefighter, again, while wearing a gun and a vest. I went to the police per our workplace violence policy. That person ends up no longer being a police officer, but that was my duty as chief to protect my firefighters. But guess who gets sued? Right, by the police officer, and me and 20,000 other people, right? But nonetheless, you do the right thing, and oftentimes you get sued. So that's as little as I'm going to say about that, but I get it. When you react, now things happen.
That is totally consistent with the research I'm doing on personality disorders and the people who are leading to a lot of the litigation in the fire service, because the very people who are spinning up the violence and rationalizing why it's okay for them to exercise violence are very likely to be the ones that are willing to use the legal system to get back at you for doing the right thing. Okay. And I think we've got to get better at recognizing these people. But I kind of come from the personality disorder part of this, that if we can diagnose them or get them the help that they need, then we're going to be so much better off dealing with it early rather than waiting until it ends up in some sort of a violent confrontation or litigation or whatever it may lead to. So, and I'll, that's research going on and into the future.
I should be case study number 2 on that. Trust me. The thing I was
well, maybe we'll take you up on that.
Feel free. Okay, so now we're headed back to the Fifth Circuit, who's been in the news with us for a lot of different things. This is probably more of interest for our constitutional lawyers. I'm going to sum this down. You can expand it all you want, but I'm going to sum it and really bring this closer, because it has one really interesting, again, more lawyer-based interest. But the Fifth Circuit Court of Appeals, this is a federal court, conservative court, very well-known court, but down Louisiana, which is a great place to visit, by the way, most beautiful courthouse I've ever seen. In any event, they upheld the conviction of a man. He was sentenced to 40 years in prison for stabbing a firefighter at a scene. And here's the short of it. Short of it is that in 2014, these firefighters are at a scene of a wildfire. This sounds so similar to one we just had. What is it, like less than a month ago? In any event, he stabs the firefighter, and another firefighter going to his aid was also threatened to be stabbed. In any event, the guy, runs away or whatever. They catch the assailant. The police were called, paramedics were called, etc. Anyway, they arrest the guy. He admits to stabbing him, right? And he says, look, I want to go back to prison. He refers to it as a home. I kind of think like Shawshank Redemption. He's institutionalized or something. In any event, and he said, it's hard making it out of prison. I didn't want to get out. And he just said that firefighter was in the wrong place at the wrong time. In any event, he's given his Miranda warnings, which, as you know, you have the right to remain silent. And if you remain silent, that right will not be used against you. Now, that's a key part of the Miranda, right? That you can remain silent and it won't be used against you. But here, and the way most places use that won't be used against you mean if you don't defend yourself by making comments, we won't assume you're guilty, right? But here, he claims temporary insanity. And the assailant says, well, I was temporarily insane because of a medication reaction. Yet, he had made other rational statements of, like, I want to go back to prison, etc. He had made other rational statements that were consistent with being sane. So the court, although they upheld the federal court, so this went through the trial court, right, and then goes up a level to the Fifth Circuit, again, a very smart court. It was the first time, allegedly, the court had this issue. And I'm not, strictly a constitutional lawyer, but I've never heard anything like this either. Mm-hmm. What they said is, listen, the prosecutor used the assailant's right to remain silent as proof against him that he was sane. Saying that, right?
It's complicated. Yeah.
It's complicated, but the court said, listen, Miranda's Miranda. You cannot use the right to remain silent against you for any reasons, right? Now, fortunately, the court said there is so much other proof that he wasn't insane, that that he was sane, that it didn't matter. But it's just a constitutional lawyer's issue. It just happens to involve stabbing a firefighter. But I won't go on more because I think it's not, Well,
I think there may be some, for example, some arson investigators that frequent our site and that may be interested because they end up doing interrogations and they have to deal with Miranda. And it's the point. It's not that it's going to come up during the interview, but when a witness says they don't want to talk, well, they don't want to talk, and that's the end of it. But here's an example of where the witness actually talked, and then you actually get him in the interrogation room, turn the recorder on, and he invokes, his right to remain silent, which is fine. Then he claims I was insane, and therefore you can't use any of the things I said before. And the prosecutor seeks to say, wait a minute, how can you say you were insane when you invoked, insane people don't invoke their right to remain silent? And the court said, no, you can't use that, but it wasn't prejudicial. So at the end of the day, he's going to stay in jail.
As I read the case, I was a little more confused. And again, we're getting a little off, but Miranda rights have to be given when two things happen, just so people understand. It's not that you're being asked questions. It's when you're being kind of like Gary. It's not just like because you're asked questions. It's because your freedom, you're not free to leave, you're in custody and you're being asked questions. Right. So it's not just stopping somebody on the street and saying, hey, did you commit that crime? You can keep walking, but did you do that? That's okay. But once you're in custody, so my question is, when were his Miranda rights read to him? Because presumably he was in custody at the time, but the Miranda that was challenged happened later on. But he made the mistake, he made the statements earlier on, at least, and maybe I just didn't read it right, but it seems like the statements came before Miranda. And so I was questioning, wait a minute, why wasn't Miranda put right when he was in the handcuffs or right when you seized him or found him? I don't know, but obviously the Fifth Circuit's way smarter than I am. So
I think some of the comments, remember, it's an interrogation. So if you're not interrogating somebody, it's not a Miranda situation. So if somebody just said, yeah, I stabbed them, and yes, I set the fire, then they voluntarily offer that.
But once you're in custody, you're being interrogated. Any question when your freedom is restricted,
that's right.
You're in custody.
That's right. But if you're not asked the question and you just offer it, you're not being interrogated.
Of course. Right.
So,
right. So those are the pieces I was missing, but that's more on the constitutional law side. And I love that stuff.
Interesting case. Interesting.
Okay, so this one I really got to kind of jump to you on, mostly because I didn't have time to prepare for it, but the final one in Port Houston.
Port Houston, yeah, it's an interesting case. It has to do with union free speech, and you can read it. I don't want to get too far into the details of it because we can get lost in the weeds. But essentially, the issue is they had some firefighters that were alleging that there was some hazing and harassment going on in the workplace. The department initiated an investigation. The investigation concluded that there had been some inappropriate conduct, behavior, etc. And I think there was a total of 6 people that were disciplined over it. Okay, now many of these happen to be union officials, and what the firefighters alleged was that they had been asking for some shift changes. Let me see if I can get exactly to the details here. But they were looking.
Yeah, I thought it was hours. It was about hours, like 48, 26.
Yeah, they wanted to go to they wanted to change their schedule to a was it 24, a 4896. They wanted to go to a 4896. They had some pay parity concerns. And they had some concerns regarding morale and turnover in the department. So bottom line is what they were saying is we were doing our job as union reps. The department disciplined us for this hazing incident or this hazing and pattern of hazing and harassment. But that was just a pretext. What they really were doing was they were retaliating against us for our exercise of our union activities, our union advocacy. So, one of the issues now, this is it's an interesting theory. There is a First Amendment right to free speech. Obviously, we talk about that all the time. There's also a First Amendment right to association, freedom of association, and very often union activities get kind of in that sort of mix there with the First Amendment right to free speech and right of association. We don't see a lot of cases like that because in my state, and I'm sure your state, Brad, in New York, you have a state labor board, so that if a union feels it's being discriminated against or union reps are being discriminated against, you file an unfair labor practice, and that's the normal way that you handle that. In Texas, collective bargaining is done more on a local level. It's enacted
with a 6-shooter, I think.
Yeah, they it's Texas, and but they handle it more on a local level, and there's no venue to take an unfair labor practice claim. I guess that's probably the best way to say it. So what these firefighters, when they were terminated, did was they sought to invoke the First Amendment. And the court essentially said, yes, that there is a First Amendment protection for both union speech and certainly for free speech. And if you were advocating certain things, yes, but you can't connect the you can't connect the retaliation, which was your termination, with your speech, that it's too disconnected, that there's no proof that you were retaliated against. It's yes, you were terminated, and yes, you have a right to free speech, but you can't make the connection. And the case gets into some of the details on exactly how that is. But it's a good point that if you're going to invoke sort of that retaliation question, you've got to be able to connect the adverse action to your advocacy on behalf of the union. And again, they weren't able to do that. So interesting case for those who are into that. I think most states that have collective bargaining, certainly if this happened in Rhode Island, we'd be going to the Rhode Island State Labor Board with it. We would not be going to federal court. But
same in New York, we'd be going to something called PERB.
Yeah, exactly, PERB. Yeah. So Texas doesn't have that option. So now they may have some other options within their municipality. And I believe there is some other litigation going on in this. And also, just one caveat here: this was a magistrate's recommendation. In federal court, you have magistrates who work under the sort of the umbrella of a U.S. District Court judge. They do a lot of the factual background.
And usually followed.
And right. Right. And so the magistrate issues an opinion. It goes to the federal district court judge. Both sides look at what the magistrate said. They'll write a brief and argue that it shouldn't be followed or it should be followed. And then the federal judge will then basically either confirm or write their own opinion on it. So it's not the final thing. And certainly they have some appeal rights as well. So.
Anything in beyond the blog we need to discuss?
Yeah, let me see. Let me take a look on beyond the blog. Let's see. I had it open. Where the heck is it?
And as you're looking, I'll encourage anybody watching today, if you want to do a little Family Medical Leave Act for like 4 or 5 hours and you want to become an expert in FMLA, that's coming up Wednesday. Yep. And it's the second time we've done it. We're excited. Which is a great, you want to talk about toxic employees and understanding how to prevent issues. That's the one to attend.
Yeah. I mean, I'm not aware of any career departments that's not dealing with sick leave abuse and trying to manage it. And you can't manage sick leave abuse if you don't follow the FMLA. It's a trap waiting for you. You've got to have your FMLA down before you can move on to addressing sick leave abuse. So and I know a lot of chiefs out there are under a lot of pressure from their local elected officials over this issue. So, it's got to,
on that, as you're looking, the one thing I learned from our listeners, viewers on the last time we did the FMLA a number of months ago, some of them felt like FMLA was intended to be a gift of a grant of additional time. And once we broke on this format, once we broke that thought that this isn't additional time, this isn't a gift, this is a minimum threshold. So if you're already doing the minimum, this isn't on top of that. And I thought people were blown away by saying, oh, I thought it was and more, and another 12 weeks. And I'm like, no, that's not what this is. And that has a significant financial impact. And you're right, we've got to, anyway, so hopefully people will sign up if they haven't already.
Sure. All right, here we go. First one, Austin settled a case. There was a female firefighter who was filmed by one of her officers, hidden camera type of thing, which is about I've got at least a dozen cases in the database of that.
Right.
Yeah, it's an ongoing problem. So they settled with her, I think $85,000. She ended up getting settled. Lincoln, Nebraska has just had a tough time with various discrimination suits, and I'm not sure why. I know a number of people from that department got a lot of respect for them, and I'm not sure what the problem is, but there's an article on some of their suits there. San Diego, city of San Diego filing a suit against the foam manufacturers, the AFFF foam manufacturers. Just there's got to be now thousands of lawsuits, thousands of lawsuits on this. And I get contacted once or twice a week looking for referrals. I don't take the cases, but I've got some attorneys that
Aaron Brockovich around here. So.
Yeah, it's quite a bit. Had a firefighter arrested for transporting and harboring non-citizens for financial gain. That was down in Puerto Rico. Again, I actually have there the San Francisco firefighter cases. I'm sorry, San Francisco firefighters who refused to get the vaccine are being terminated. So another article on that. So.
Great, and I'm not going to go there, but great issue with abortion. I mean, abortion, vaccine, same issue, right to protect your body, same issue. I won't go too much there because I don't want to be, shot, egged or anything else. But, when you talk about your right to your body and the right to protect yourself and others and to control your body, I don't know how we have a discussion about vaccine and it's not abortion.
Yeah. So. All right. Well, let's talk about something that is not going to start. I don't even want to say World War III because that But
I think that was it.
Maybe
not among our listeners, but
So, all right. Okay. Well, that's going to do it for another edition of Fire Law Roundup. Thanks, Brad, and we'll see you Wednesday. Really, folks, think about attending that FMLA class and. Please subscribe and please click like. And also, you may notice I've got my special agent out there, Malcolm, who's going to be working on some videos for us. But we're going to be kind of breaking some of this stuff up. So you may see some 10-minute clips of today's webinar, today's discussion here, popping up on YouTube as well. So we'll try to make it a little bit more bite-sized chunks, but you know, the full version will still be here as well. So, but please subscribe, please like, please share with your friends. Please help us get up over 500. We're up to almost 350 now. So we're on our way, and we really appreciate the support.